They both are. Okay, Mr. Vaka, you're first.
Good morning. Nice to see everybody. George Vaka with Vaka Law Group representing the appellant Homeward Realty Real Estate. We're asking this court to reverse a judgment entered for the defendant appellee Shabbachi following a trial in which the trial court involuntarily dismissed my client's breach of contract case. And I'd like to reserve 5 minutes for rebuttal if I might. The facts of this case are very straightforward. They may seem so familiar because I think they're kind of like out of a horn book on contracts. The defendant entered into an exclusive listing agreement with my client for the sale of his property. The contract had a termination date of May 15th, 2019, and a quote protection period of 30 days thereafter. So that if the broker procured a contract within that period of time, the defendant was obligated to pay a commission. On May 24th of 2019, the defendant entered into a contract with Tiffany and Robert Michael for the sale of the property with a closing date on August 1 of 2019. The closing did not occur on August 1 of 2019 because the home that the defendant was constructing was not completed, and the parties entered into an addendum extending the closing until September 15 of 2019. And it had a proviso that if construction was not finished, there would be an automatic extension of an additional 30 days. On September 20, 2019, the parties entered into yet another addendum extending the closing until October 15 of 2019. And an additional 30-day period of construction was not finished. On November 15, 2000.
Mr. Vaka, can I interrupt you? I think having worked with Judge Northcutt, Judge Kelly before, I'm sure everybody, they both are well-versed in the facts and the sequence. Let me see if I could kind of jump in with a question that kind of concerns me a bit and to have you an opportunity to address it. You would agree that this contract was an as-is contract. There's no question about
it.
The
construction contract was an as-is contract.
Correct.
The brokerage agreement was the standard brokerage agreement.
Correct. I'm just focusing on the as-is.
Sure.
And then we also agree with me that we're dealing with sophisticated, clients, both sides, you're talking about a realtor who's purchasing that. And looking at the purchase agreement, I think we all would agree it's not really a model of clarity because it was trying to seem to suggest that the construction would be completed, but yet the buyers themselves drafted the as-is contract. And even though there's been an acknowledgement, it's not really the ideal contract where construction was ongoing. And so my question to you is that even if the purchase contract is considered to be ambiguous, and the fact that the issue in this case deals with an ongoing, I guess let me jump to the chase. Ultimately, it was agreed by both sides when they settled this matter that there was no fault, there was no issue whatsoever. Both of them decided to go their separate ways. That was ultimately what occurred. And then we have the however clause where they ended up selling it to another people. How does that all play in this matter, given the fact that you're taking the position that there was a breach of contract?
Sure. Your Honor, in my opinion, it's very simple. There was a breach of contract no later than November 15th of 2019. At that point in time, even if you were to construe the sales contract the way that the trial court here did, which was even though all the parties testified that it was their intention to have a home constructed that would be conveyed to the Michaels, and that you would interpret the contract contrary to the intention of the parties. Here, the closing was to occur no later than November 15th of 2019. So even if there was no home constructed, there was a requirement that there be a closing on November 15th of 2019, which did not occur. As we mentioned in our, certainly in our reply brief, if you took the position that the Shabbachi's attorney later took after November 15th, that in some fashion there was to be a closing, I think it was January 6th of 2020, and that the Michaels somehow breached the contract by not agreeing to this new closing date. The remedy under the law is very simple. If it was the intention of the parties to close on November 15th, Mr. Shabbachi had two choices. He could have asked the court for damages, or he could have asked the court for specific performance. Those were his options. Stiffing his broker was not one of the options, which is precisely what they did. So from my perspective, the key date here is not what happens after November 15th, is November 15th, because my client had earned the commission back in May when they procured a willing buyer. And there's a sales contract for a willing buyer. So what
And
that
if I may, Mr. Vaka, and I know you mentioned the brief that your clients were always, I mean, there was always, like, not your clients, that there was always ready and willing and able to have a buyer. The question is, I'm looking at the facts, were they really ready, willing, and able if the construction was not completed? I thought there was testimony presented that everybody was relying on the fact that the home will be constructed, that construction will be completed.
Yes.
And wasn't there testimony somewhere in the record, I thought I read somewhere, that said that ultimately the Michael said, we weren't planning to, if construction was not completed, we were not planning to close on this. So how does that reconcile with the fact that your client was able to procure, a buyer that was ready, willing, and able to close?
Certainly. So I think that determination needs to be made in May of 2019 when the parties entered into the contract. And in May of 2019, it was the intention of Mr. Shabbachi. He's testified over and over and over again that it was always his intention to deliver a completed house, that he had done so, I believe, on 40 plus occasions previously. And it was the intention of the Michaels to purchase the house that he said he was going to construct. So that's the operative time period. If it later turns out that because Mr. Shabbachi was not able to complete construction, either because his builder ran out on him or his builder wanted more money or whatever, the fact that they may have changed their mind as to being a ready, willing, and able buyer, although certainly understandable if the agreement of the parties was to construct a home and there was no home to then transfer. At the time that the contract was entered into in May of 2019, there clearly was a ready, willing, and able buyer. The buyer went ahead and qualified for a conventional loan as required in the purchase agreement, and they were ready to do it if Mr. Shabbachi had fulfilled his obligations under the contract, which he clearly did not. So I understand there may be some technical deficiency in this contract, but most respectfully, I don't understand how you can look at this set of facts and not come to the conclusion that it was the intention of the parties, which of course is the cardinal rule of contract interpretation. Your honors Judge Northcutt made reference to statutory construction, and he may not be able to do that anymore, but certainly with contracts, the court is able to do so. And the cardinal rule of contract construction, as I understand it, is the courts do everything they can to give effect to the intention of the parties. And this ruling could not be more opposite of what the intention of the parties was, as testified to by every party who was a part of that agreement. So, but I think my client fulfilled its duty in May of 2019 when there was a contract for sale of the property. They went and obtained the financing, so they were ready, willing, and they clearly were able. So they satisfied that obligation back in May of 2019. What happened thereafter doesn't affect what my client did to honor the terms of the contract and to earn a brokerage commission as of that date. The court knows that this is the second time around for this case in front of this court. Judge Lucas wrote an opinion in which he looked at the contract. So the last time we were here, Mr. Shabbachi was taking the position that the however clause under the policy excused his obligation to pay a commission because he thereafter, after the termination date, and after this lawsuit had been filed, he hired another broker and who sold the house for another either $150,000 or $200,000. And that issue, the facts of it could not be more clear. Mr. Shabbachi's testimony was, it was his intention throughout the course of these extensions to deliver a constructed, completed house to Mr. and Mrs. Michael. That contract for sale expired, terminated, however you'd like to refer to it, on November 15th of 2019. Mr. Shabbachi's intention on November 15th of 2019, according to his testimony, was to deliver a completed house to the Michaels. So there clearly was no reliance, even though he filed an affidavit, and you can say that the affidavit creates a fact issue, and that's fine, and then the case needs to be remanded for determination of that. But I think the facts are very clear that he did not rely upon the however clause, that his testimony was unequivocal, that he intended to complete the contract on November 15th, and he simply didn't do it. To me, as I mentioned when I started this argument, this is the kind of case that I recall reading about in first-year contracts in law school, where there's a promise made, there's a promise kept, and then there's a promise breached. And that breach occurred by one person and one person only. That was Mr. Shabbachi. If you agree with Mr. Mitchell's argument that the construction contract is in some fashion ambiguous, the listing agreement is not. And so to use the purchase contract as an excuse to not pay under the listing agreement makes no sense. First and foremost, they're not dependent documents. One doesn't incorporate the other. And second, most respectfully to the trial judge, I believe that the conclusion that the court reached, which of course interpretation of a contract is a matter of law and this court reviews de novo, was patently wrong. When you have every party to the agreement singing from the same page of the hymnal, saying that their intentions were to build and sell a house, where there were numerous references to finishing construction in every single one of the addendums to that contract. There is no question that the intention of the parties, they may not have expressed it perfectly, but the court's job was to give effect to the intention of the parties. And this ruling most clearly does not. So most respectfully, we would ask this court to reverse the judgment of the trial court, accept the testimony of the parties. There are no disputed issues of fact, and the court should remand with instructions to enter judgment on behalf of my client. If the court has no further questions for me, I'll save the rest of my time for rebuttal.
Thank you, Mr. Vaka.
Thank you.
Okay, Mr. Mitchell.
Yes, Your Honor. May it please the court, Mr. Vaka. I think what's missing from Mr. Vaka's argument is the fact that at no point in time did anybody ever argue that the contract was ambiguous. And that's a point that I make in my brief, and it's an important point because I too agree that the cardinal rule of contract construction is that you have to give effect to the party's intent. However, one of the very first rules that you get to after that is if nobody's claiming, if the contract's not ambiguous and nobody claimed it was below and nobody's claimed it is in this brief, Mr. Vaka said, and I think maybe this was a mistake, that my argument is that it was ambiguous. It's not. And my argument is clearly that it's unambiguous, and so was theirs below and in their brief. Then you have to give effect to the contract as written within its four corners. So really, at the end of the day, all this talk about what Ms. Michael said or what my client said or what somebody else said, all of that testimony cannot be considered by the lower court and respectfully by this court either. Unless a contract is ambiguous, you don't go to parole evidence. You don't go to the other rules of contract construction. You have to enforce it as written and give intent as written. Now, at the end of the day, that's what the lower court did. And Your Honor, Judge Kuzam had pointed out very clearly, and I agree with this, that it was a bad contract. It was the as-is kind of standard contract that you typically have for a completed house that's been, built for several years or whatever, between a typical buyer and a typical seller. But at the end of the day, when you look through the contract itself, and we'll get to the addendums in a minute, there is only one mention of construction in the entire contract, and that's under the additional terms. And all it says is that my client was obligated to provide the signature sheets for the specifications for the construction within 15 days, which there's no dispute that my client did. So it obviously did not breach that. Beyond that, there is nothing in this contract about construction, much less completion of construction. The addendums mention construction, and they say, if it's not done by closing, you're entitled to an automatic addendum. Then there's another one that says if it's not done, you're entitled to an automatic extension. But again, nothing in there required construction to be complete. And in fact, there are several areas in this contract that say the opposite. Paragraph 1C of the contract obligates the appellees to deliver the property together with all existing improvements and fixtures. Paragraph 11 requires my clients to maintain the property, including the lawn, shrubbery, and pool, in the condition existing as of the effective date. Paragraph 12B says my client, that the other side's entitled to a walkthrough solely to confirm that all of the items of personal property are on the property and to verify that the seller has maintained the property as required by the as-is maintenance agreement. So if you were to read into this contract, which requires you to add terms, and this is the thing that the lower court got perfectly right, is that you would have to add a term to this contract to buy into the appellant's argument. Even if you were to do that, it all of a sudden creates a repugnancy in the contract, because if you read in a term that says you have to complete construction, that doesn't jive with the rest of the terms that says my client's obligation is simply to deliver it as existing at the time of signing. I would agree with you, Judge Kuzam, that we never really did have a ready, willing, and able buyer here. Certainly, the question was asked, and I confirmed it because you brought up the testimony at trial. And again, we don't really get to that, so I'm going a little beyond it. But if we were to look at the testimony at trial, Ms. Michael, who was the buyer and also a licensed broker, said that they were not willing to purchase the property unless construction was complete. So again, you have to add terms to get to the appellant's position. The lower court correctly concluded that you can't do that. It relied on good case law. I cited a couple of cases, especially one from the second DCA, the Azalea Park case, 127 Southern 2nd, 121. It's an oldie but a goodie, Your Honors, 1961. And it says, the absence of a provision from a contract is evidence of an intention to exclude it rather than an intention to include it. So again, the absence of the completion of construction obviously manifests an intention to exclude it. I had a secondary argument below, which I'll touch on briefly here, and that is, okay, so let's say for argument's sake that the parties just missed the boat on this thing, used the wrong contract, there's nothing in there about completion of construction. Then what we have here is a failure of a meeting of the minds, which means that the contract itself, and of course I'm referring to the purchase contract, not the listing contract, is unenforceable, voidable, whatever you want to call it, but there can be no breach in that situation either. At the end of the day, the appellants are relying on section in the listing agreement, section 8D2, which allows for a commission if my client fails to sign a contract, not the issue here, or defaults on an executed contract or agrees with the buyer to cancel it. The two parties to the actual purchase and sale agreement agreed There was no default. There was no cancellation. As you put, Judge Kuzam, they just agreed to let it expire and go their separate ways. If the parties to the agreement aren't calling for a default, then I don't understand how the broker gets to call for a default later on down the road. The lower court focused on the contract itself since no ambiguity was claimed and saw the obvious that there is no requirement for completion of construction. Therefore, there could have been no breach, and this court should affirm. Thank you.
Thank you. I almost feel like I'm in an alternate universe. So we have an MLS agreement that specifically advertises the property with a rendering of what Mr. Shabbachi is going to build on the property based upon that representation that was authorized by Mr. Shabbachi. Mr. and Mrs. Michaels decide that they want to purchase the property in accordance with the rendering that's on the MLS agreement. That testimony is undisputed because the listing agent testified to that. And Mr. and Mrs. Michaels enter in an agreement where the parties are in agreement that Mr. Shabbachi bought the property, knocked down an existing structure, so there wouldn't be a structure for him to transfer unless he built the one he promised to build. And according to Mr. Shabbachi, a contract for the sale of a new house does not require a new house. And most respectfully, I would agree with Mr. Mitchell, except an interpretation of a contract that leads to an absurd result is not the one that the court enforces. And that's precisely what happened here. We have a contract for the sale of a new house. The builder doesn't build the house, and somehow that's not a breach of contract. And Mr. Mitchell should be commended for coming up with this argument, which he did after the contract expired. As he did, as I pointed out in our brief, it seems to have had its genesis in an email to the Michaels lawyers when they were trying to obtain their deposit back. And then there's this settlement agreement. So if the contract didn't contemplate any of this, there was no need for a settlement agreement. There was no need to settle anything because according to their argument, the contract's clear and unambiguous, and Mr. Shabbachi performed under the contract. And most respectfully, under any view of these facts, I don't know how one can reasonably reach the conclusion that Mr. Shabbachi performed under either the listing agreement or the contract, because it was always the intention of these parties, as testified to by all the parties, that there was going to be a new home constructed on the property that he was going to convey. Mr. Shabbachi testified that had the builder not asked for more money, he would have conveyed the property to Mr. and Mrs. Michaels with a new home on it. He reiterated he would have done so in August, in September, October, and November. The reason why this house didn't get built was because the builder wanted more money. Mr. Shabbachi tried to squeeze that money out of the Michaels after he had a contract because the deal became a bad deal because South Tampa real estate went through the roof at this period of time. And so Mr. Shabbachi was able to capitalize on that to the expense of the Michaels and to the expense of my client, who had done everything that they had agreed to do. So most respectfully, I appreciate this, a lot of this lawyer talk, and we're going to go through this and this. The bottom line is you have to construe this contract as not being one that's for the sale of a home that Mr. Shabbachi promised to build in order to reach the result. And most respectfully, I think that result is absurd under these circumstances, and I would ask the court to reverse this judgment with instructions on remand to enter judgment for my client.
Thank you, Vaka, Mr. Vaka. Thank you both. You need to leave our virtual courtroom, and to do that, you click the button on the lower right-hand corner of your Zoom screen that either says leave or that is a pictograph of a person going through a door.
Thank you. Happy holidays to all.
Hey, same to you.
Thank you.
Thank you, Your Honors. Have a great day.
Okay, the court will be in recess for 10 minutes.